Welcome to Litigation Nation. I'm your host, Jack Sanker, along with my co-host, Vanessa Watkins. This is the show where we round up some of the most important and interesting legal news of the past couple of weeks. As a reminder, you could find us on Apple Podcasts, Spotify, YouTube, or wherever you get your podcasts. Vanessa, what do we have up today?
Well, perhaps against my better judgment, I am taking on the tall task of summarizing the 119 pages comprising the opinion, concurrences, and dissents in the Trump versus United States ruling, which was just published by the Supreme Court on July 1st of 2024 and deals with the issues of presidential immunity in criminal cases.
And I'm going to be covering an interesting petition for certiorari to the Supreme Court out of Ohio on the question of whether the Occupational Safety and Health Act is itself an unconstitutional delegation of power. And this ties in with the recent Chevron decisions and is a good point of discussion for us here on the show. All that and more, here's what you need to know.
Okay, so we just had this monumental ruling come down in Trump versus United States. And I have to say, a few months ago, when Jack and I sat down and started discussing me coming on the podcast and what we wanted to cover, we expressly said we were not going to be another, SCOTUS blog, and let's leave that to, the DC people. But this court has just come down with monumentally changing, just crazy decision after decision. So it's so hard to turn away from it. And especially this one with the issue of whether a president or former president can be immune from criminal acts. There's just been an uproar on social media. People are just picking parts of the opinion out and sensationalizing it. And so I thought it might be good to just kind of walk through it, give a summary of what I understand to be the findings and then the dissents and just what it means going forward. And, what is the reaction from legal community scholars, some of the former lawyers of presidents who maybe now would have been immune for criminal acts. So let's dive in. All right. So back in August of 2023, former President Donald Trump was indicted by a federal grand jury in DC regarding his alleged efforts to overturn the results of the 2020 presidential election. So in the 45-page indictment, it details allegations that after losing the election, Trump conspired to overturn it by spreading knowingly false claims of election fraud, tried to obstruct the collection and counting and certifying of the election results. And then all of this culminated in the events that occurred on January 6th. So in that case at the trial court level, Trump moved to dismiss all of the indictment, saying that he had absolute immunity from criminal prosecution for the alleged actions he took, which would fall within the core of his official duties as president. The district court denied the motion and held that former presidents do not possess federal criminal immunity for any acts committed while in office. Now, at this point, it's worth noting that in a regular criminal case, this matter would have moved forward to trial, and only after a criminal conviction would that defendant be able to appeal the court's refusal of the motion to dismiss. But in this case, the court granted an interlocutory appeal. So that means before the case proceeded to trial, they stopped everything and said, let's send this one issue up on appeal before we move forward. And it makes sense. It's, if he's immune, that's the end of the case. So they did grant the appeal. I believe the prosecutor pushed for it to go straight to the Supreme Court because he didn't want to delay things, but that was denied, and it did go to the DC Circuit Court of Appeals first. At that level, they affirmed the decision of the lower court, concluding that, quote, the separation of powers doctrine as expounded in Marbury and its progeny necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts, because the fact of the prosecution means that the former president has allegedly acted in defiance of the Congress's laws, end quote. Now, both of those courts, though, declined to decide whether the alleged actions that Trump engaged in actually involved official acts of the presidency. They just said point blank, there is no immunity. So the Supreme Court granted certiorari, and it considered the following question: whether, and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? So I just want to start with a quick explanation that actually Justice Jackson provided in her dissent, and that's just what immunity is. So just to be clear, it's an exemption from duties and liabilities imposed by law. So it's not a defense. It's saying that the law does not apply to you at all to begin with. So conferring immunity on someone essentially creates a privileged class that would be free from liability for wrongs inflicted or injuries threatened. So it is a very I don't know, specialized, I guess, thing. We don't see it much in law, because it's essentially saying even though this would otherwise be a violation of our laws, we're not even going to consider you as being liable. So our majority opinion here was written by Chief Justice Roberts. The court ultimately came down 6-3.
Wait, which 6, which 3? Just curious. I'm joking. We all
my
know.
Gosh. I was like, do I really need 6? Well, for anyone who wouldn't know, the 3 dissenters were Sotomayor, Jackson, and Kagan, which should come as no surprise. Mm-hmm. But, and I will get into this, interestingly, Amy Coney Barrett did author, I think she only dissented to one part of the majority's opinion, but I do appreciate that she takes the time to set those sort of things out. Like, she doesn't just, join the majority. Mm-hmm. She explains why maybe the court went a little too far in its ruling. So I did appreciate that, and we'll get into it. But so yes, the finding was kind of in 3 parts. A president or former president is absolutely immune from criminal prosecutions for actions taken within his conclusive and preclusive constitutional authority. So that's part 1. The second is kind of expanding outward from his core. So other acts that he takes within his presidential responsibilities. So this could be, for example, the president does have powers, but he maybe shares those with Congress. So things like that, he will be entitled to at least a presumptive immunity from criminal prosecution. So there is the opportunity for the government to try to overcome that immunity by showing, he went beyond the bounds, essentially, or how the president acted was not actually within, the 4 corners of his responsibilities. And then third, if the criminal conduct at issue comprises unofficial acts, then there is no immunity. So I will say this opinion is dense. As much as I would invite anyone who has, a free 2 hours to read through it, it's a history lesson. All of the justices are literally relying on quotes taken as far back as Alexander Hamilton's Federalist Papers from 1776. Which makes sense. I mean, those papers were to try to explain and help lay people interpret what was then the proposed Constitution in an effort to get them to ratify the signing of the Constitution. So they're really looking back to what were the founders intending when it came to the separation of powers. Yeah, I know you love that part. And I mean, rightly so, this opinion also makes repeated references to decisions that were rendered in connection with President Nixon and the Watergate scandal, as well as President Clinton. So, I mean, that's that is the only precedent that the court really has to look at, because this issue has never come up before. There has never in our history been where a president or former president is facing criminal conviction in connection with actions he took while in office. So this is uncharted territory. And I was telling Jack before we started this recording, I'm reading this majority opinion and I'm like, okay, yeah, that makes sense. I get it. It's a little bit vague. And then you get to the dissent, you're like, oh my gosh, I can see how this could go really bad depending on who's holding the office. So let's dig into it a little bit. So throughout this opinion, Justice Roberts definitely tries to impart the importance of we can't just focus on essentially President Trump and, think about this in terms of him being in office or being a former president. We have to look forward and consider more broadly, what does the office of the presidency mean? How do we ensure that whoever holds that office is able to fully engage in their duties and responsibilities? So one of the major issues that the court is concerned about is that the president needs to be able to act with the vigor and energy of the executive. That is taken from the Federalist Papers number 70. So having this looming threat of trial, judgment, imprisonment, looming over them at all times during their presidency could change how they act. It could change their decision making. It could cause them to be more cautious than they would otherwise. Now, and I don't mean to jump ahead, but I tend to agree more with the dissent in this position, particularly because if you think about it, civil lawsuits can be filed by anyone at any time. So certainly protecting the president from a civil litigation while he's in office, or at least delaying it, that to me makes sense because it doesn't have the same checks and balances as a criminal prosecution. In criminal cases, you have a grand jury. You have a prosecutor who is supposed to be acting on behalf of the people. They can't just bring a fraudulent or a claim that has no evidence behind it. They are held to a higher standard than I guess they simply are held to a higher standard than a plaintiff's attorneys.
Right.
But it's true, because you're acting on behalf of the people, and the effects of a finding against whoever the defendant is are that you could lose your right to freedom. So it's just a different standard. And so to me, as a sitting president, the threat of a civil action seems way more prevalent than the threat of a criminal action. Not to mention, it seems a lot easier to stay within the bounds of criminal law versus, a civil action can be brought for any reason. You're presenting,
you would think, yeah,
you're presenting a nuisance, you're hurting someone's feelings, you defamed them. I mean, it's just way broader under the civil landscape than it is when it comes to criminal. But either way, that was one of the major things that was really driven home in the majority's opinion. Now, on and on about, why they think that I should say Justice Roberts and the majority, why those justices think that they have the authority based on history to make this decision. But at the end of the day, again, this is new territory. So the dissent really tears apart the way that they interpret history, which I'm sure Jack will appreciate. Saying that the justices aren't the perfect historians that they think they are. And they cherry picked, what they needed in order to get the results that they got. Now, the court did get into the specific indictment against President Trump in this case. I'm going to go into those in more detail rather than the broader concepts, because I think that's what's really interesting. It did make certain rulings that will kick out some of the counts against Trump down at the trial level. Other counts have to go back to the trial court level for further investigation, essentially. And the court needs to be the gatekeeper as to whether there is evidence supporting immunity or not. So actually, two of the indictments, I'm going to deal with them together because they're similar. They involve Trump meeting with the acting attorney general and the senior Justice Department officials to discuss investigating purported election fraud. And then when the attorney general resisted Trump's request, Trump repeatedly threatened to replace him. So the court found that investigation and prosecution of crimes is a quintessential executive function. So the authority to decide how to prioritize and how aggressively to pursue legal actions against defendants who violate the law is exclusively within the president's authority. For that reason, the absolute immunity would apply. The same is true with the president's ability to appoint and remove executive officers. So even though he threatened the attorney general essentially serves at his pleasure. So his decisions on whether to remove that person, it's completely within his constitutional authority, and regardless of motives he may have had, the court said it would be improper to look at those motives. It's within his authority. It's absolute immunity. So back at the trial court level, those indictments will be stricken.
The actual ruling, the Supreme Court ruling, is sending this back to the circuit court to determine whether the specific acts are quote unquote official acts or not, right?
Yes. And so certain of it, because they said they didn't do that, at the district court level, they didn't actually brief those issues as thoroughly as they should have.
Right.
It's because that we didn't have a test for it yet. So,
was there any guidance offered in the opinion, which I didn't read, I'm sorry, but in the opinion is to determine what is, official or not, or is that up to the circuit court to determine for itself?
It's pretty loose.
Okay.
Let me just give you a couple more examples so you can kind of see how
Sure.
potentially loose it is. So one of the indictments was that Trump attempted to enlist the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. So the court found that whenever the president and vice president discuss their official responsibilities, they engage in official conduct. So even though the vice president it really serves as the president of Congress, that is his realm. The fact that he speaks to the president about things that are happening in Congress, that could directly affect the president and what he does and his duties and his responsibilities. So in that situation, the court found Trump is at least presumptively immune from prosecution. And then the question becomes really an issue of fact. So you have to look at the circumstances of, how much would Trump's ability to do his job be affected by finding him liable for his conversations with the vice president. So it's loose. Trying to see some other examples here. A lot of the rest of his indictment actually involved a bunch of different actions that essentially led up to the January 6th insurrection. But I mean, even basic things like tweeting out that people should come to the White House, addressing the public, directing them to march to the Capitol, and try to put pressure on the vice president regarding the certification proceeding. The court finds that the president possesses extraordinary power to speak to his fellow citizens and on their behalf. So it instructed the trial court to do an objective analysis of content, form, and context, and that will inform the inquiry. Right. Again, it's just so loose. And I think, depending, everything's going to come down to how it's framed.
Yeah, right. I mean, there's the stuff that's like in Article 2, which is like explicit, uh core vested powers of like the presidency, like appointing people to, agencies or like diplomatic recognition, or like the stuff that like you can pull up, the Constitution and read. That stuff is all going to be the broadest level of immunity, right?
Mhm.
It's this other level here that we're sort of we don't really know exactly what to do with. Uh and what's interesting, and I've seen people kind of bickering about this online, is if you're the president and you are genuinely of the belief that uh an act of incredible uh like fraud and deception has occurred and an election was stolen,
Mhm.
and all of the things that people said happened in 2020 happened, and you believe that, right? What what are now the limits of your quote unquote official capacity, right, as the president?
Mhm.
Like, if you believe that, then you can probably justify doing a whole bunch of stuff,
Well, and
and
the
let's
crazy part, Jack, is that you don't even need mens rea doesn't come into it.
sure, yeah,
And,
right.
so the prosecutor can't even probe into what was his intent, or the court can't even consider that. It's just as a duty to ensure fair election procedures. Okay, so what actions can he take within that?
Well, I
Um,
mean, right. That's the thing. That's the rub here, because if it can just be the fig leaf of anything that I can call an official act, because I can find the pretext of one thing or another, to to put over it,
mhm,
then that's going to justify everything, right? And I
mhm.
would like to think that the court understands that, and also that the circuit court will understand that, on remand. But I mean, we'll see.
Yeah, it's eh, I mean, when we go back to, on remand, there's going to be, I think that it's going to be a couple months, that they're going to have to do more investigating. I'm sure there's going to be more briefing. It just seems like, especially, I mean, the indictment itself is already 45 pages long. There's a lot of information in there. And the fact that there's not enough for a judge to make a decision on, whether the president acted within the scope of his authority and functions. I mean, it almost seems like the court now needs to presume that all of the actions he took were immune. So it's actually on the prosecutor to show that allowing this criminal trial to go forward will not, I guess, improperly intrude on the authority and the functions of the executive branch. And
Mhm.
that kind of seems like that's the bar that has to be passed.
Right. It's
Um,
the uh whether the prosecution can demonstrate there's no dangers of intrusion on the authority. Yeah.
right, right. Um, which, I mean, I don't know. I guess I don't understand how he's going to do that, but we'll see.
So there's some again, there's a really interesting kind of looking at the fallout from this. Like the famous like Saturday Night Massacre that Nixon was maligned for and everything during the fallout from Watergate.
Mhm.
That is an example of um Nixon basically threatening to fire a bunch of folks, or firing people who don't want to play ball and do things the way he wants to do things.
Mhm.
That, at least according to this opinion, would be uh, legal. And I think at the time, I don't think there ever was a ruling on it, but I think at the time what was legal, because that's the president's ability to, via Article 2, to hire and fire folks within the executive agencies.
Mhm.
He or she has absolute authority to do so, for whatever reason. There's no like for cause requirement in that scenario. So when Trump, for example, was like threatening to fire people from the DOJ who don't want to investigate election fraud or whatever, if I looking at the opinion, it looks like that would be absolute immunity in that scenario, right?
Yeah, absolutely. So there actually was a finding that in Nixon, so it was Nixon versus Fitzgerald.
Mm.
He was
Okay, yeah.
Fitzgerald was an Air Force employee, and I think soon after Nixon took office, he fired him, saying that it was, a restructuring or reorganization. But Fitzgerald said it was actually because of testimony he gave before Congress that Nixon didn't like. So he did bring a civil lawsuit against him, and the court found that the president had absolute immunity, because like you said, that was within, the core of the executive's authority.
Like, even if there, and I didn't read it, but even if the finding was that Nixon was fired this individual because he testified before Congress, that's still protected. Like, that's the
Right.
extent of immunity that they get.
Right.
Yeah.
Because the court said if you start looking into the reasoning behind things, well, then if you allow that inquiry, and this is where there's a difference between immunity and a defense. So if you are gonna allow a defense, that means that the court will consider, all right, what was Nixon really thinking at the time? But the court said, no, we're not even getting to that. We don't care what he was thinking. We don't care what his motives were. He had absolute authority to hire and fire. He is immune from any civil litigation as a result of his exercise of those privileges.
Right.
So that is now the court is applying that absolute to criminal claims when the president is acting within his exclusive authority, and it has to be exclusive under the Constitution. So, like I said, there's a lot of overlap where the president shares certain powers with Congress. It's presumptive immunity, it can be overcome. So those cases can be brought, and there will still be, I'm sure, motions to dismiss, but they're at least not going to get kicked out in the first instance. There's going to be, some discovery on those. But yeah, putting, I don't know, absolute immunity on without, I guess the scary part for me is that I understand why within the Nixon firing, I understand why the court explained, we're not going to look into what was his intent, but it gets a little scarier when you're dealing with criminal actions.
Yeah, right. I mean, I understand that too. I think what the court is saying is that whether civil or criminal prosecution of either could be politically motivated, therefore it would impinge on the rights of, and of the executive, and like civil or criminal, like, being sued for money damages, it can be worse depending on what they are than being prosecuted for a low-level felony or misdemeanor. So, I get that to some extent.
So going back to the opinion for a minute, and this is going to Justice Amy Coney Barrett's concurrence in part. Well, the part where she differed is that, and here's actually, she gives a really good analogy to explain why she differs on this. So I'll explain it. Actually, I'll probably quote that verbatim, but it's essentially that the majority ruled that once a president's conduct is deemed absolutely immune, or even if the prosecutor is not able to overcome that hurdle. So essentially, anytime there's a finding of immunity, whatever act is deemed immune cannot serve as evidence in a criminal prosecution against the president for actions that maybe he took beyond his executive privilege. To put a finer point on it, Justice Barrett gives this example. So consider a federal bribery statute that would forbid any public official to seek or accept a thing of value for or because of an official act. The Constitution, of course, does not authorize a president to seek or accept bribes, so the government may prosecute him if he does so. Yet, excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution. So to make sense of charges alleging a quid pro quo, the jury must be allowed to hear about both the quid and the quo, even if the quo standing alone could not be a basis for the president's criminal liability. And her objection to that is pretty obvious. The court is concerned about allowing evidence of official acts for which the president cannot be criminally liable for to be heard by the jury, because it could prejudice the jury. But we have rules of evidence to handle that.
Right.
So, a trial court can explain, this is why you can consider this evidence and you can't consider it for this purpose. There's just ways to deal with those things. It happens every day in criminal court.
Yeah, I mean, right. What's interesting is we do handle those every day, and then a lot of people, anyone who tries cases, will say, okay, well, those instructions are worthless. Once a jury's heard it, they've heard it. And there's, to some extent that's true, but that's what we do for everyone else. So like, why are we making a new rule that's only applicable in this case?
Well, and think about it in terms of this case. They've found certain acts that he took are absolutely immune. So his discussions with the attorney general. Now, let's say also his discussions with Vice President Pence, he ends up getting immunity for those. So how are you going to explain the series of events leading up to maybe a charge that's allowed to go through, like him directing the crowd to storm the Capitol because Pence wouldn't, do the recount or send the ballots back? Like, how do you even get to that point without explaining everything, leading up to that? Or can't give those facts to the jury. I don't know. It seems like that really is hamstringing the ability to bring any criminal action if it's, based on other criminal acts that the president's immune from.
Mm-hmm.
So I thought that was an interesting dissent, and I thought she brought up a good point there. Now, and I don't want to belabor this too much, but the dissent is kind of amazing. I mean, Justice Sotomayor does not hold any punches. I think, Jack, you and I had talked about this before, just the way that she wrote this. I mean, she is citing Dobbs to get back at the majority. She says this official acts immunity has, quote, no firm grounding in constitutional text, history, or precedent, end quote, quoting to the Dobbs majority opinion. Because it is true. I mean, this issue has never been before the court. So it's not like they can ground themselves in anything, yet they're attempting to. The majority makes selective cites to history. Hamilton made clear, however, that the president would be distinct from the King of England and would be held personally responsible as opposed to untouchable. So essentially the majority is relying on Hamilton, yet completely ignoring that he made clear we're going to hold our presidents accountable.
Mm-hmm. As an aside on Amy Coney Barrett's ruling or discussion of admissibility and all that stuff, quick aside, I do have to point out, never a trial judge. She was never a trial judge, and in fact, I don't believe that she has any trial experience. Although, if I'm wrong about that, we'll edit something in here. But she was on the she's on a court,
right?
Yeah, 3 years on the Court of Appeals, and then right to the Supreme Court. So, this whole what's admissible, what isn't thing is a bit, that is a bigger can of worms, and I think this opinion even gives credence to, because if there's not admissible, then there's not admissible for certain purposes. Like to what you mentioned, and just, I don't know, the way that it's kind of written out of this opinion is only the way that someone would write it if they did not have a lot of trial experience. I'll put it that way.
That's an interesting point. Yeah, true.
Yeah.
Two other interesting points raised by Justice Sotomayor, and not that this is conclusive, but as a litigator, this was intriguing to me. She quoted Trump's own lawyers during his second impeachment trial, and the statements that they made to senators, saying that Trump's conduct related to January 6th, if the senators declined to impeach him, it would not leave him, quote, in any way above the law, end quote. The lawyers insisted that a former president, quote, is like any other citizen and can be tried in a court of law, end quote. Quote, no former office holder is immune. If my colleagues on this side of the chamber actually think that President Trump committed a criminal offense after he is out of office, you go and arrest him, end quote. So, I mean, these lawyers' statements are definitely but here, because obviously now they're, backing off from all of that, and he's not being treated like any other citizen, or at least, that's what his attorneys are arguing now. But just, from a litigator standpoint, that's always interesting to see that, because there are times in a case where you argue one thing and then maybe later on it doesn't serve you so well or comes back to bite you. But the transcript is forever. So another interesting thing she brought up was the Watergate tapes. So so she says, after the Watergate tapes revealed President Nixon's misuse of official power to obstruct the FBI's investigation of the Watergate burglary, President Ford pardoned Nixon. So both Ford's pardon and Nixon's acceptance of the pardon necessarily rested on the understanding that the former president faced potential criminal liability, or else, why would they have done that? Which I thought was an interesting point too. So even though we don't have any lawsuits that we can point to, we can point to the actions of, different players throughout history to show that it was always the understanding that a president could be held criminally liable. That's the argument she's trying to make.
Yeah, I mean, there is some, when we say like unprecedented, that's a word that gets thrown out a lot. I mean, this is like a new thing, and is not, we don't have experience dealing with this. And I mean, the issue is, so when you're deciding from the justice's perspectives, deciding this case, it's like you're deciding this case itself, and then you are trying to decide every other case that could come after it, and making sure that the way that you decided this one is not going to, blow up in your face, 10, 20, or 100 years from now, right? So it is tough to be in this position. I understand there's slippery slope argument, which kind of underlies all of this, which is, if the president doesn't have absolute immunity on certain things, and the president is going to be like gun shy to act. And, this goes back to what I was saying earlier. What if there actually was a scenario where some massive election fraud happened? And like, let's, assume for a moment that all of those horrible things that people that, whatever, like, what if that actually happened? Right. What if it really happened? Then the president should be justified, and I would say ought to be able to, I don't know, whatever you do in that scenario, like, do you deploy the National Guard? Like, do you know what I mean? Like, what do you do? Right. And so I get that. I do like that ability, preserving that ability for the president to act without fear of like retribution down the road. That seems to be the slippery slope that the all of the concurring justices are worried about here. And I do think it's like worthwhile to keep that in mind, even though like maybe we don't like the outcome here, or if you don't like the outcome here or whatever. I think that we're going to be right back where we started pretty soon, getting into this official acts question. And especially the lack of kind of guidance on that. And, I don't know how the court's going to handle that in particular.
Yeah, that part too is going to be difficult. And, the court didn't really provide too much guidance. Justice Roberts tried to, I guess, explain how certain acts that Trump took should have a presumption of immunity. Like, so he kind of provided that framework, but then didn't totally explain. Definitely, I don't think gave any guidance to the prosecutor about how to overcome it.
Yeah, there's like a rebuttable presumption that can be overcome, but like I at least when I skimmed it, didn't see exactly how.
Right.
Without really getting into the kind of mens rea aspect of this, which I don't think they're allowed to.
Well, yeah, especially when you can't get into that, then
You
you're
know, like it, right? Because everything. I mean, that's what Nixon said. Well, if the president did it, it's not illegal. You know,
right,
that's
right.
that's
Yeah,
it's a and
that's
it's
the
like,
same idea. Yeah.
yeah.
Uh-huh.
I mean, hey, Nixon, vindicated.
Yes.
He's yeah. Bring him back.
That's
And
well, go ahead.
yeah, no. So I just I understand that idea, and I do understand. I remember like the Bill Clinton case, which was like it was like a big a huge portion of my con law class for whatever reason in law school was on the Clinton case, and we these three different buckets: the um official acts, the kind of gray area in between, and then the strictly private acts, and
Hmm.
all that stuff is. I mean, this isn't out of the blue. You know, this standard has existed before and was applied to Bill Clinton
Hmm.
in the 90s and everything else. Um, you know, but right, if it's very interesting because I do think that if a case like this were to have happened in the 90s um or before, I think that the court, and I can't remember which case it was, it's really bothering me now, but they drew a distinction between like campaign acts and like official acts as president. And you know, in campaign acts on are not, you know, if you're acting um as a person who's running for the United States and you're acting in your capacity as a candidate for president, like, you know, what you don't have um same privileges and immunities as you do if you're acting as the president. So, you know, you're giving a rally for yourself to be reelected. It's different rules apply in that scenario than if you're giving the State of the Union. It
It's
seems like here they're kind of bulldozing that distinction as well, because, or at least they're avoiding it, because I, you know, it's there's like proponents of kind of what happened around some of these things around like January 6th and whatever will say that they uh that this was an you know, these acts were official and that they were, you know, like Trump trying to protect the election or whatever you want to call it. I think you could also look at it and say he was acting as a candidate, though. He was saying like I should have won. I actually did win. Like I'm continuing my campaign. For those of you who support me, should show up and you know, do this rally or whatever. And I haven't seen any discussion of that either, which is, I don't know. It seems to me to blur the line more between candidate and the actual office of the executive. And I would have liked to have seen the justices spend some time on that.
Yeah, it actually, I just pulled up the opinion again because I do remember reading something about that, but they didn't cite to that case. It doesn't look like.
Yeah.
The government though did argue that his conduct didn't qualify as official conduct, but as campaign conduct.
Yeah, yeah, yeah.
So they did try to draw that distinction. They don't cite a case for it, but that brings up another issue of, okay, so he was a sitting president. So because at the time he was running, I mean, I think the government is trying to make that just like, let's not just give him immunity because he was a sitting president. He was an incumbent is what I'm trying to say. As opposed to, how his campaign conduct should not be treated differently than somebody who is not an incumbent.
Yeah.
Like we should, actually look at what we're again, but then it goes to intent. I was going to say what were the purpose of his actions, but
Yeah, I mean, actually, here's the part I was thinking of here, and I'll read it from the opinion. It's on page 26. And it says, quote, the government disagreed, contending that this alleged conduct does not qualify as official conduct, but is campaign conduct. And then it says, on Trump's view, the alleged conduct qualifies as official because it was undertaken to ensure the integrity of the proper administration of federal elections. And after that, the word campaign does not appear in the opinion. So I don't think the court addresses that.
No, it doesn't. It definitely skirts over it.
So I guess that's for the circuit court to decide.
It seems that way. Yeah, I'm really interested to see how this plays out. I do not envy, who is it? District Court Judge Tanya Chutkin. Yeah, so she is the one that will be presiding over this. So just to be clear of how this all wrapped up, so certain charges were kicked out. The other ones are being remanded back down to the district court level. The judge is going to have to, I'm sure, have the parties submit more briefing or evidentiary hearing or something to that effect, because now effectively this judge is the gatekeeper.
Right.
So this ruling definitely makes clear that in the first instance, the judge needs to decide whether immunity applies or it doesn't. Yeah, the court doesn't want that issue to go to the jury. The court doesn't want to delay that issue for appeal. When it comes to the president, all those issues need to be decided up front.
Mm-hmm.
Let's see what else. So it doesn't seem likely that this case will go, if any of these charges are found to be able to move forward, that immunity will not apply. It doesn't seem like trial will happen before our election. I think there's probably going to be a couple months of investigation and hearings on this issue. And then it looks like the judge had already told Trump's legal team that she would give them approximately 90 days to prepare for trial. I just think that time's going to get eaten up pretty quickly. So
yeah, and I saw already the and the other, Trump cases and stuff, which we don't need to get into, but their lawyers are already seizing this opinion and using it. I want to say it was the I want to say it was the
well, the New York one that we covered, where he was just convicted of the 34 counts. Yeah, so
right.
the sentencing was supposed to be I think July 15th or right around mid-July, and they just pushed it back to September to, I guess, allow for arguments to be made regarding this ruling that just came out. And I haven't looked into this issue, so this is totally off the cuff, but my understanding was all of those charges or convictions were regarding Trump's activity before he was elected president. So I'm not sure how this opinion will affect that, because this has to do with obviously the execution of powers under the executive branch.
Also, I don't know that this opinion is retroactive is another thing.
Oh yeah, sure, that
like
too.
It's conviction in state court. I don't know that, an opinion 2 months later from Supreme Court gets to undo it or not.
Mm-hmm.
But the federal documents case, like the Mar-a-Lago banker's boxes in the bathroom case, that I think that's a pretty obvious application of this. They'll say he took the documents for official purposes. Like that's or whatever,
sure.
right?
For sure.
And which is also, it'll be very interesting because he can only be acting in his official capacity of president if he is still the actual president, and which would require the Supreme Court to rule on whether or not he was president in February, March, and April of 20 and really the year after.
Interesting.
So the Supreme Court's going to have to decide whether he won the election or not, is what it boils down to. So
yeah.
I don't know. They'll probably kick that one. They probably won't touch it.
Yeah.
Wow. Yeah. Okay. Interesting.
Okay. Because I just think that her writing is impressive, and it is doomsday, but Justice Sotomayor, I think she just, takes the gravity of the majority's decision to heart in a way that it is chilling and it is scary. But it's, she sees the potential for what this ruling could do. So I just wanted to quote this last part of her dissent. The president of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way under the majority's reasoning, he will now be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, 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 immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's messaging today. Never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide by will not provide a backstop. With fear for our democracy, I dissent.
Yeah, that jumped out to me because like I remember very vividly I think justified objections to a specific event during the Obama administration, which was when President Obama authorized a drone strike on a U.S. citizen who was designated as an enemy combatant, and there was a whole ordeal. It was a whole political cycle of whether the president could do that. I don't remember the guy's name, unfortunately. But it was an American citizen who I think was affiliated with the Taliban, and President Obama authorized a drone strike, which killed him. And that was like, there was a time where there were a lot of people that were saying, well, this is a criminal act. This is outside the scope of, what the president can do. And I know it doesn't help to like both sides or like, to call someone a hypocrite. Everyone's a hypocrite. Don't get me wrong. But like I remember that very vividly, or there was like opposition to that. Like this person is a U.S. citizen, therefore they're entitled to due process rights. Therefore, summary execution via drone is illegal, and therefore Obama, should be charged or whatever. Well, I mean, this would retroactively clear him that, discharging the powers of the presidency to, order a strike on a enemy combatant or whatever is like probably a quote unquote official act, So there's not going to be civil or criminal liability for that anytime soon, Barack. Not that anyone was worried, but I guess my point is like this, however you slice it, like the way that we understood immunity as evidenced by even people that wanted to like go after the last Democratic president, before Joe Biden, like it has expanded. No one, not even, I don't think Barack Obama and his proponents were saying I'm immune from this. There was other justifications for it. But no one was saying you can't come after me for this. I'm the president. I'm immune from criminal acts committed in this official capacity. This is an expansion of that rule. People will just say it's a clarification and that this rule has already existed. Maybe that's the case, but it certainly has never been pushed up to the limit like this, where we've had someone draw a line, and now we have that line. And I think that the line is a little further than we all probably expected. And and that's just it is what it is. I understand.
Well, I think it goes back to, sorry to cut you off. Do you want to finish your thought? I think this court has just, as we've seen decision after decision after decision, is really honing in on separation of powers. And I think it would have been, I don't know, potentially easy or, splitting the baby to say that, yes, the president's actions taken in his official capacity, pursuant to his authority, are presumptively immune, period, and leave it at that.
Yes.
But they separated that first part based on the separation of powers, saying there are certain powers that are exclusive to the executive branch. The founders never intended for Congress to have any oversight in that, never intended for the judiciary to be able to make any rulings based on that. So don't even
get me started.
But that's what they're doing. But that is, what they're saying, that if it is exclusive to the executive branch, period, that's it, he's immune.
Right. Yeah. I mean, we'll get there one of these days. I'm gonna um uh, I'm gonna try to convert you to being Marbury pilled, where Supreme Court does not have the right of judicial review. That is the biggest separation of powers, seizing of powers by the judicial branch in our history. But that's a separate issue.
Yep. Gosh,
Um,
another fun one.
yeah.
Fun, scary. I say fun loosely. Fun in that we just spent 45 minutes discussing it, but yeah, there's definitely more to be seen though. I mean, this is how this plays out will become more clear over the next couple months, but
I mean, I think what we're going to get out of this, one way or the other, is we will get a set of rules by which, because we didn't know, we did not know expressly what the rules were when it came to either suing or prosecuting presidents for certain things they did while in office. Like we had some idea from the Clinton cases in the 90s, and we had some idea from Nixon in the 70s. But this will result in a number of new rules on how that works, and then every president going forward will have those rules and the benefit of those when making decisions one way or the other. And that's either going to help or hurt us long term. I would say that, and it's just that's the trade-off here. And we'll have to see. That's I think kind of the veiled threat of maybe getting prosecuted for criminal acts while in office, like even if it wasn't clearly articulated, probably kept some presidents sometime along the last 250 years in line. They would like this idea of, oh boy, I want to do this, but I'm worried that I might get thrown in jail after I'm done here. So I better not. I'm willing to bet that that's happened more than once to a sitting president where they've been like, okay, never mind. And now that's kind of off, and maybe that's off the table now. So like, maybe we're going to get some crazy decision making from the executive. I don't know, but
right. Well, or even just the understanding that you're going to leave office at some point, and your opposing party may be the one filling your spot. So don't take action that could come back at you someday, sort of thing. That probably kept people in line too.
So I'm going to be covering actually the denial of a petition for certiorari to the Supreme Court, which is in itself not really newsworthy and not usually wouldn't be something that we cover, but this one jumped out because it's in an area of law that I practice and kind of specialize in, which is OSHA. And so it was on my radar for that reasons, but also it's kind of speaks broadly to more of the constitutional issues that we're seeing regarding the administrative state delegation of powers from Congress to executive agencies and so on. So this is the all states refractory contractors versus Julie Su. Julie Su is the acting Secretary of Labor, then the de facto head of OSHA right now. And the petitioners here were an Ohio-based contractor. They're challenging the constitutional authority of OSHA, which is kind of similar to what we've seen discussed in the recent rulings on Chevron deference and even some cases going back to 2019, which we'll talk about here. This specific court does seem to have the administrative state in their sights and looks to be taking on these types of cases. So this is kind of something to keep your eye on here. And I think this case is an interesting illustration of that. So 7 of the justices here declined to grant certiorari. Justice Gorsuch and Justice Thomas dissented, and Justice Thomas actually drafted a dissenting opinion. It's short, it's only 3 pages, but it is worth noting. And Justice Thomas points out that the Occupational Health and Safety Act was granted legislative power to promulgate rules to enforce any rules that it, quote, deems reasonably necessary or appropriate to OSHA. And what he's gearing up for and what the general complaint from the conservative justices is that Congress cannot delegate rulemaking authority to an executive agency. The rulemaking authority, legislative authority of the United States government is vested entirely with Congress, et cetera, et cetera. He doesn't initially take that outright hard line and say that Congress cannot delegate this kind of authority, but he ends up pretty close to it in effect. And I'll quote from his short opinion here. Quote, under our precedents, a delegation of authority is constitutional so long as relevant statutes set out an intelligible principle to guide the agency's exercise of authority. The Court of Appeals of the Sixth Circuit upheld the delegation of authority to the Occupational Safety and Health Administration under this intelligible principle test over, and this was a dissent that occurred in the Sixth Circuit, over Judge Nalbanian's dissent. And Justice Thomas continues here, quote, I continue to adhere to my view that the intelligible principle test does not adequately reinforce the Constitution's allocation of legislative power. And here he actually cites to a Gorsuch dissent in the Gundy versus United States case from 2019. And in that case, Gorsuch says the intelligible principle test has no basis in the original meaning of the Constitution, in history, or even in our precedents. Thomas continues here, quote, this case exemplifies the problem. Congress purported to empower an administrative agency to impose whatever workplace safety standards it deems appropriate. That power extends to virtually every business in the United States. This agency claims authority to regulate everything from a lawnmower's design to the level of contact between trainers and whales at SeaWorld, unquote. So he later goes on to say that OSHA might be the broadest delegation of power to an administrative agency found in the U.S. Code. And he kind of ends here with a quote again, quote, if this far-reaching grant of authority does not impermissibly confer legislative power on an agency, it's hard to imagine what would. It would be no less objectionable if Congress gave the Internal Revenue Service authority to impose any tax on a particular person that it deems appropriate, and I doubt any jurist would sustain such a delegation, unquote. Now, the reason I'm talking about this, and it's become a bit of a theme on the show, is this re-examination of the Supreme Court's tendency to delve into this kind of historical analysis of, basing their decisions on, well, this is our history, this is our tradition, this is how the U.S. has always done things, based on, what I think is the justice sitting here today, and therefore I'm going to decide the law in accordance with that history and tradition. I have voiced objection to that and how that happens and the way in which the Supreme Court kind of does that analysis before on a couple of different episodes here in the show. And I'm kind of going back to the well on that today. If only because I don't think that this is correct technically or factually. As an aside, the first executive agency that was established in U.S. history was actually as early as 1789, of course, and this is the State Department. That's an executive agency, but it's only executing executive powers. It's held by the executive branch. So it's not exactly what we're talking about, but it goes to show that the administrative state, as it were, was contemplated and immediately put into effect the moment that the Constitution was ratified, right? I'm really going to just nitpick here on Thomas's quotation of the Gorsuch opinion, which is to the effect that there's no history of upholding this kind of delegation of congressional power to the executive branch, because frankly, yes, there is. And Gorsuch, even when you read his opinion that Thomas is relying on here, he acknowledges as much. So the question I'm kind of discussing here is just whether there is a history and tradition in our country or in our Supreme Court precedent of this type of delegation from Congress to the executive for rulemaking purposes. And I just think that Justice Thomas is wrong when he says that there isn't. The biggest example and the kind of earliest example that I could find with the little bit of research I was able to do here is the J.W. Hampton Jr. and Company case versus the United States. This is from 1928. And this is where the quote unquote intelligible principle test comes from. Here's the portion of that opinion which really underlies a lot of what administrative law, as we understand it today, is. Quote, Congress shall lay down by legislative act an intelligible principle to which the person or body authorized to fix such rates, and this is a tax case, by the way, to fix such rates is directed to conform. Such legislative action is not a forbidden delegation of legislative power. If it is thought wise to vary the customs duties according to changing conditions of production at home and abroad, this gets into taxing and tariffs and things like that. Uh, it may authorize the chief executive to carry out this purpose with the advisory assistance of a tariff commission appointed under congressional authority. So that's the J.W. Hampton case, 1928. And in that case, the Supreme Court is expressly saying Congress can delegate rulemaking and enforcement authority to an executive agency so long as they're an intelligible principle to which that rulemaking body is going to act under. That's in accordance with this congressional authority, right? Since then, that case has been cited up and down through all the federal circuits and, of course, the Supreme Court to justify empowering congressional agencies and executive agencies, rather, with carrying out acts of Congress and making rules themselves that will be enforced by themselves. So think of like the EPA, OSHA is a great example, things like that. In this opinion, by the way, since we're kind of talking about, history and tradition here, it's worth noting that this opinion from 1928 was authored by Justice Taft, as in like William Howard Taft, who was the 27th president, and who was kind of famous in his day for actually pushing back against the expansion of executive power, and back against specifically Teddy Roosevelt, who was kind of all about the expansion of executive power in his time, before he ultimately got stabbed in the back by Teddy Roosevelt in the election of 1912. Teddy Roosevelt kind of Ross Perot'd Taft, and he ran as a third-party candidate, and handed the election to Woodrow Wilson. But I digress. The point is here that Thomas and Gorsuch say this stuff is all outside of our history and tradition, and yet there's an example of a particularly anti-expansionist justice in Taft, someone who actually served as president, authoring an opinion which says, sure, Congress can delegate some power to the executive in certain circumstances, so long as there is an intelligible principle that Congress sets out in the delegation of rulemaking and enforcement power. So it's Gorsuch explains this away, and he kind of does so in a throwaway paragraph in a dissent in the Gundy case from 2019. And we don't really need to get into that. He just basically says, no, the J.W. Hampton case doesn't say what we all think it does. It says something different, etc. No citation to authority on Gorsuch's part. No really getting into the specifics of that delegation, or whether it had happened before, or whether there is indeed a history of this happening in our congressional record or not, things like that. He just kind of just says, hey, we think this says this, but it didn't. And now the Gundy opinion from 2019 is being used to bolster what Thomas is saying in his dissent on this denial of certiorari, all of which is the two conservative justices saying, look, we don't have a congressional history of doing this. We don't have Supreme Court jurisprudence of holding this up, and we shouldn't be doing it this way because we never have really in the past. And that's just, frankly, not true.
So if I can interject for a minute.
Yeah.
And this is maybe just me being too practical about this issue, but I mean, we have agencies for a variety of different areas. I mean, OSHA is just one. I think you mentioned the EPA. I don't know, others don't come to mind off the top of my head, but there are a bunch of different agencies that we have always allowed to regulate, I guess, kind of internally, because they are, quote unquote, the experts in whatever area that may be. So I'm just curious, what is the alternative to that? Is the expectation that Congress is going to now take a look at what these guidelines are and make their own revisions that will become effective immediately? Are they going to wipe the whole thing clear and start fresh? I mean, I just don't, maybe because in our lifetime, it's just always been so obvious that, yes, of course, you're going to let these agencies who understand the issues, so what is the alternative?
Well, it depends on kind of where we go politically, right? But there is a bill that's actually pending. I don't know if it's ever been introduced or anything, but it's the REINS Act, REINS. idea behind that, as far as I understand it, is that these executive agencies can go about recommending rules that fall under their normal like purview. Like the EPA can go ahead and recommend what acceptable lead levels are or something like that, but they'll all have to then be codified into law by Congress, right? So it basically says the agencies can no longer issue their own rules that would have the force of law. It has to be run through Congress, which means that these agencies, whether you like them or not, their rulemaking authority, goes away and gets subject to the kind of political willy-nilly that happens in our modern Congress, I think, which is to say that none of the rules ever get passed.
Well,
Is
I was thinking that too. I mean, part of this is almost like, what we call judicial economy. So I don't know if you want to put congressional economy, like they can't handle
For sure.
everything, so some things need to be delegated. So I could see them just getting bogged down in a full session with just one of the agency's, new proposals.
Exactly. That's, I think, the point, by the way, from proponents of that type of legislation is like they don't want new rules. And that's a kind of a libertarian political way of looking at things. And I'm not making a merit judgment on that one way or the other, but I think ultimately, like, if you point out correctly, this is going to make it hard for any of these new rules to go into effect. I think opponents of that type of legislation would say good,
Mm-hmm, mm-hmm.
So yeah, and the Supreme Court, for all that we've talked about how they're supposed to be non-political and everything else, what they're saying here is effectively, or at least what Thomas is implying here, is that we can't delegate that type of broad rulemaking authority to an executive agency. Violates the delegation of powers and all that stuff, whether you like it or not. But what really bothers me is Gorsuch saying, like, well, when we never have before, so this is all new. We haven't been doing this, and it's like, here's an example that's 96 years old that I was able to find pretty quickly, and insofar as the Supreme Court, we've talked about this on previous episodes, they like to kind of clothe these decisions in sticking with the legal and political history of the United States. This is, to me, another example of them kind of either making something up or just doing bad historical scholarship in that regard. And the result is they get to kind of claim to be apolitical by saying, no, we're just looking at what our history is here when making a pretty heavily politically charged decision. And some examples of like some things that I think that the Supreme Court, ought to get into, especially if they're going to talk about this, which neither Gorsuch did. Obviously, Thomas didn't. Not that he would do it in a certiorari dissent, but still, you would expect to see this somewhere. Is like, off the top of my head, some things I would want to know. When was the first congressional delegation of rulemaking authority to an executive agency? Like, when was that? What date did that first happen? Because, like I said, I found an example of an opinion on that happening from 1928. Does it go back much further? Because now it seems like you would call that a tradition, right? If we're over 100 years. When was the first executive agency established anyways? I think I mentioned before that was the State Department in 1789 or 1788. And then, are there other examples of Congress delegating rulemaking authority to different executive branches that go back even further? And like off the top of my head there, I'm thinking about, actually, Danessa, do you want to guess what period in American history I'm thinking of?
Shoot, what is it that you're obsessed with?
It would be the Reconstruction era.
Yes.
But the Freedmen's Bureau, this was the Freedmen's Bureau. Congress delegated all sorts of power to the Freedmen's Bureau. And this was, I don't know if this is the earliest example, but I can tell you that that would be part of the quote unquote history and tradition of how we do things in this country that seems to just be ignored whenever it's convenient for the Supreme Court to do so. And that's a bugaboo of mine that I'm going to talk about as often as I can, I think, or at least as often as, the audience doesn't get bored with it. But for now, I'm going to keep beating this drum on the level of historical analysis that's coming out of the Supreme Court, which I think is usually pretty bad. And that it shouldn't be guiding these decisions to begin with. One of the reasons that we're covering, the denial of certiorari is in the wake of the recent decision on the Chevron deference, and the court really throwing that out. It's guided by similar principles. It's this idea that the administrative delegation of powers between the executive and congressional branches have gone too far, et cetera, et cetera. And we're not going to dive into that decision here on the episode today. We might get into it later, but if you're listening to this podcast and you're interested in this type of news, undoubtedly you've seen the headlines about the Chevron decision. So we wanted to just kind of pick up where those would have left off and give you maybe a preview of where this is going, which is, 2 of the 9 justices already expressing at least some intent to maybe get rid of OSHA or get rid of OSHA's rulemaking and enforcement capacity. So this is how decisions like that, could affect your sort of day to day.
All right. Well, the Supreme Court is now on summer recess until it says, first Monday in October. So you'll have a little reprieve, listeners, on us talking about Supreme Court cases. But this has been interesting. Thank you, Jack, for hearing me out on this very complex ruling. And that's all we have for this week. Remember to like us, follow us wherever you get your podcasts, Apple, Spotify, YouTube, and we'll have a new show coming out in 2 weeks. Thanks for listening.
Thanks, everyone.